I'm in the USA. I'm starting a new business, and I think the name I want to use is very similar to an already registered mark. I'm curious if those could weigh in on the name I want to use. Please note this is not the actual business name, but these names will demonstrate a similarity. The current registered name is Slap Yo Mama. The name I want to use is Slap My Mama. Both the same products. Let's see if we got the rest.
Yeah, that's going to be a no-go.
Okay.
USPTO is going to shoot that down instantly.
Okay. So just
the reason being,
yo versus my.
Yeah. It doesn't really have that much trademark significance, right? You know, my, your, whatever, right? Slap and mama are kind of the two most important words. They come at the beginning and at the end. Everything in the middle is kind of fluff. Yeah. USPTO is going to say the trademarks are similar in sight, sound, and meaning, and they also have identical products or services. So when you have both of those that's similar, you're going to get denied. If you have one that's almost exact but the other is very different, then you likely get through the process and vice versa. But if they're both similar,
you always have to have one of those that's different.
Yep. How similar are the names? How similar are the services or products, right?
So that was sight, sound, and meaning.
Yep. That's kind of the trilogy we talk about when it comes to how similar the brands are to each other. You know, are they similar in sight, sound, or meaning? And then how similar are the products and services? Are they in the same class of services and products? Right? Are they different? Are they related? So, like, for example, you know, I imagine this is probably an apparel company. So Slap Yo Mama, Slap My Mama, you know, they're similar, but what if one of them was a jewelry company, the other's an apparel company? Well, you'd say, well, they're not the same class. You know, jewelry is different than apparel, but at the USPTO, they're all basically the same for likelihood of confusion analysis purposes. So, you know, that's something that clients need to be aware of. Is just because it's not the same class doesn't mean you can't be denied by a existing registration or application.
Got it. And even if that, you know, the first one on your example, clothing versus jewelry, they didn't even list jewelry. You're saying it's still going to be too close from
still too close because you know the USPTO has found that consumers recognize the providers of jewelry also typically sell apparel and vice versa.
Yep.